17. I think, as Lucy's already said, for this introductory section, would you please keep your microphones muted, but you can have your videos on. We're using a remote microphone here in the DPEA office, so could you just give a quick indication just to confirm that you can hear me as well? I know you could hear Lucy. Okay, I think that's fine. Thank you. So we're here to talk about the proposed application by Corriegarth to Windfarm Limited for consent to construct and operate a 14-turbine wind farm on the Corriegarth estate, approximately 15 kilometres northeast of Fort Augustus, 9 kilometres southeast of Foyers. My name's Tammy Swift-Adams, and I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division. I've been appointed jointly with Karen Hayward, one of the assistant chief reporters, to hold the inquiry and report to the Scottish ministers on this application, which has been submitted under Section 36 of the Electricity Act 1989. The Scottish Government, the Scottish ministers will decide whether or not to approve the application once they've considered our report. Ms. Hayward is also with us today, as is our colleague Lucy Wakeham, who you met, and Lucy will stay online to help in case we run into any technical difficulties. A few housekeeping matters I'll just mention before we move into the main agenda items. Firstly, the meeting is being broadcast live. It's also being recorded, and in due course it will become available on the DPEA website as an archive. By participating today, you are agreeing to being filmed, and to the images and the sound recordings being stored and used for training purposes, also for historical records, which are available to members of the public. You might find it useful to use the grid view that's available on this meeting platform, so you can see everybody clearly. Please remember to unmute your microphone when you're speaking. Please wave or speak if you need to get my attention. For example, if you want me to speak up or slow down or pause at any point. Please switch mobiles off so they don't make any noise for the duration of the meeting. Here in the DPEA office, we're adhering to the current applicable COVID-19 restrictions and guidance, and hopefully you're doing likewise, particularly if you're in offices or sharing space with colleagues. We have the room here booked until 5 o'clock, but I don't expect to need anything like that amount of time. I haven't planned a formal break, but if we're still going and there's still a lot to get through after an hour, I'll pause and see if we want to put a break in at that point. We haven't got any fire alarms planned, so if you hear a fire alarm at this end, me and Karen will need to vacate the room. Please remember today's meeting is only about the inquiry processes and arrangements, not about the merits of the case, and we won't have any discussions on detail of that nature. We've circulated the agenda 2 weeks ago, and we'll progress through that as quickly as we can, pausing for discussion if we need to, particularly on matters where there may be differences between parties on procedure. If we need to pause at any point for a chat, we'll do that, pause the meeting and give people a time to come back, particularly so people watching online know when we're going to resume discussions as well. Okay, so moving on to item 2. I'd like to invite the lead participant for each team to introduce themselves and their colleagues, and could you please state which part each of you will be playing in the proceedings going forward. And I start with the applicant.
Thank you, ma'am. Good afternoon. My name is Marcus Trinnick. I'm a solicitor of King's Counsel. I'm instructed by Fraser Gillis, a partner in Wright Johnson Mackenzie. And you will see on the screen 3 people sitting in a row. One is Fraser Gillis. The one to his right is Amy McDougall of Wright Johnson Mackenzie. And to his right, to her right rather, is Julie Adams, and to her right, Stuart Davidson, both of the applicant company. Those are the people participating from the applicant's perspective.
Thank you. And are you using any additional witnesses for the further processes beyond who's here today?
Yes, ma'am. Giving evidence on landscape and visual issues will be Dan Walker of Land Use Consultants. And giving evidence on policy issues will be David Bell, who runs his own company.
Okay. Thank you. And the council, please.
Good afternoon. My name's James Findlay, King's Counsel. I'm an advocate in Scotland and England and Wales. I'm instructed by Rhoda Banfro, who was appearing on screen a moment ago. She's come back. Excellent, thank you. And also in attendance this afternoon is Councillor David Fraser. It'd probably only be me that's talking this afternoon. We don't yet have witnesses identified for any subsequent hearing, and at an appropriate moment, there's another timetabling issue that I'd like to inform you about.
Okay, we can come on to that. Thank you. Mountaineering Scotland.
Yeah, my name's Dave Gordon. There's only me. Mountaineering Scotland. I'm already well known to the other parties.
Okay, nice to meet you. Thank you all. Thank you all for that. I'll move on to agenda item 3, which relates to the code of practice. Whilst there are no prescribed rules for handling inquiries under the Electricity Act, the Scottish Government does have a code of practice, which is modelled on the 2013 planning appeals regulations. We expect to apply that code in this case. I think you've had a link to that already on the agenda, and I'll put one into the meeting note as well as a web link. Basically, the code allows for a flexible approach so that we can select the appropriate procedures for each issue that requires further consideration, whether that be inquiry session, hearing session, or further written submissions. For many issues, the information already submitted is likely to be sufficient. For the benefit of anybody observing online, the absence of further procedure on a particular issue doesn't lessen the importance of that issue. And when we write our report for the Scottish Ministers, we'll be taking into account all of the environmental information, all of the consultation responses, and all letters of representation too, whether or not they've been the subject of further procedure. Very briefly, for the benefit of anybody that hasn't been involved in an inquiry of this nature before, I'll just very quickly explain the different types of procedure that will be coming up. Hearing session is a structured discussion led by a reporter. It's suitable for issues of a less technical nature, but where there are some differences between parties. Inquiry sessions are more formal, particularly suited to particularly technical issues. Those are chaired by reporters, but each party is invited to present information and evidence for cross-examination by those with opposing views. There's usually legal representation at inquiry sessions with lawyers doing the cross-examination, the reporter also asking questions. Further written submissions are simply for us as reporters to ask different parties to provide information and invite other parties to comment on that. And finally, site visits are also part of the evidence gathering. And we'll talk about that under a later agenda item. You'll see from Appendix 1 the agenda that we've already set out our thoughts on which issues need further process and what the appropriate process would be, and we'll come on to that as well under some of the agenda items coming up under items 5 and 6. Have people got any questions at this point before I go on to item 4? No? Okay, so item 4 is on additional information, and it's really mainly an opportunity for you to give updates that might be necessary. We've got on the agenda a reference to the cumulative landscape and visual impact assessment. The applicant position statement expresses an intention to update that to because the baseline's moved forward since it was prepared. I note there was an email today with some information on it on the proposed approach to preparing that. I'm presuming the council may want to comment on that, but might not be ready to do so yet. So council, have you seen that, and would you like a bit of time to come back on that?
Yes, we have seen it. I think on its face, we don't have any particular comments, but I think given that we've only just seen it today, it would be useful to have, say, 7 days to comment on it if needed. And we would try and do it obviously as quicker than that if we can. Okay, but it looks sensible at the first sight.
Okay, yeah, that should be fine, and I'll confirm that. Well, I won't confirm it in the PEM note because that's also 7 days, but I think 7 days is fine. I was going to ask about the timetable for preparing the update as well. I don't think there's been mention of that yet.
Yes, do you know? 17th of February will be the latest submission date.
Okay.
And there's no other additional information proposed.
Okay. So when that's ready, Ms Hayward and I both need hard copies, particularly the visualisations. Do other parties need hard copies of the updated documents too? Not Mountaineering Scotland.
Highland Council would like one hard copy.
Okay, that's fine. Okay. I'm just checking where I've got to. Okay, so we've covered the timescale and we're all content with that. In terms of other timing, I've got other suggested dates coming up under agenda item 7. We'll need updated positions from parties on changes to relevant local and national policy as well. Since planning statements were prepared, I think there's been quite a lot of movement on that. There's been an update to onshore wind policy on 21st of December, and NPF4 has also been approved by the Scottish Parliament on 11th of January and should be adopted by the Scottish Ministers on 13th of February. Under the next agenda item, there's a proposed hearing session on policy to discuss. Are parties happy to update positions on policy as part of their statements and recognitions for the hearing?
Yes.
Yeah. Okay, and I
Yes, and perhaps I can pick up the comment I made earlier about in light of NPF4 and the onshore wind policy statement, the council is likely to be taking this matter back to a committee on the 8th of February. Obviously, I can't say what's going to happen in respect to that, but certainly in setting any dates thereafter, it would, I think, be a reasonable course to not set too much work to be done, if any, before the 8th of February or sometime thereafter, just in case a different decision is made and objection. It also, in light of a policy issue, as I think others are aware, that the usual officer that represents the council, Simon Hindson, is leaving the council in mid-February, so that there's going to be a need to obtain different policy evidence on the basis the matter goes ahead. So for those reasons, I thought I'd raise that at this stage, just so that when decisions are taken with respect to the timetable, that could potentially be factored in.
Okay, thank you. Yeah, we can remember that as we go through. I don't think there's many dates that early, but we can double check as we go through. I think I skipped over a point I meant to make earlier, which is when the landscape and visual impact update is available. In terms of other parties commenting on that, are you happy to do that as part of your preparation for the session on landscape and visual impact as well? Yeah.
Yes, it saves duplication.
Yeah, that's fine. So I'd confirm that. Okay.
Excuse me, may I just clarify? I mean, I would hope to take in the new planning policies and the additional information from the applicant and submit that together with essentially the bulk of our original objection unchanged as a single updated document, if that would be an acceptable way to proceed.
Okay, do other parties have any comment on that? No. I'll bring forward, I've got a note later on of a suggested date for that. I had suggested the 7th of March. So with what we've heard so far about the other work underway, is that still a plausible date for you to do that?
You're talking to me?
Yes, sorry.
Yeah, sorry, yes, that would be fine.
Okay. Well, thank you very much. Is there any other information or any other updates that parties are anticipating at this point? I was wondering whether there was anything due on Peat in light of comments from SEPA and Nature Scott in some of their representations. Nothing planned? Yes,
ma'am. If we are on that Appendix 1 looking through, I'm perfectly content with the procedures proposed. So far as Peat is concerned, I perhaps need to know from you exactly what you have in mind in terms of what you may be requiring.
Okay, well, the reason that's noted under this item and in Appendix 1 as well, it's just picking up some of the comments we saw in the responses from SEPA, consultation responses from them and from Nature Scott. So we note they're not making objections. SEPA, for example, have referred to the finalisation of peat management plans, discussing micrositing and using that as an opportunity to try and move into less deep peat, I believe. And Nature Scott have also talked about the extent of restored habitats. So some of those points, the reason we've got that down for further written submissions is just so we can clarify what they're looking for and seek comments on that.
That's fine. I'm certainly there is a draft report already prepared responding to Nature Scott's position, as most recently set out in its letter of the 31st of May. And we'll take on board the SEPA points as well. My request is that rather than go straight into written submissions, if you would allow us 1 month, say, about a month from now, to enable Nature Scott and the applicant to discuss matters, it may be that there's happy agreement and we don't need to indulge in written submissions. But if you would give us that month, that would be appreciated.
Okay, I'll make a note of that. We can confirm that in the note of the meeting.
Thank you.
That comes back. Okay, so it's just the reason that was under this agenda item was just to make sure there wasn't anything separate already planned, you know, before we get to any further written submission requests. Okay, so I can move on to agenda item 5, and that is the appendix which we've just begun to discuss, Appendix 1 to the agenda, which sets out the various issues discussed relevant to the case and proposes a number of further procedures. This is broadly in line with the suggestion that was made by the applicant and comments from the council. There is proposed to be an inquiry session on landscape and visual impact. We note that it's visual impact in particular that is the base of the council's objection, but if that information could be looked at in the context of the landscape as well, that would be helpful. I know the council had suggested just a hearing on that, but we think an inquiry session probably is appropriate. And then we've got a hearing session down for policy and another for conditions, which is in line with both the council and the applicant's suggestions. And there are 2 items for which we're suggesting further written submissions. One is peat, which we've just discussed. The other is traffic and transportation. The reason that's down is that in the council's committee report, there is a list of various road improvements to which contributions it's suggested should be made, and which we think we need more clarity on, and we need to give the applicant a chance to comment once it's a bit clearer what the council's proposing. So that is the reason we've picked that one up. On everything else, we don't think we need any further written procedures. We can consider the information that's already before us. Are there any more comments on those proposals?
If I may, just on the transport, we know this is an outstanding issue, but I'm going to make the same request. If you would give us a month from or thereabouts from today's date to discuss matters with the Highland Council, if we're in agreement, there may not be a need for further written submissions. If we're not, then you can set a timetable.
Okay, that's helpful. Thank you very much. Are there any other comments?
Yeah, just on policy, I know what our position was, but as Ms Hayward will be aware, there are a number of policy sessions between those involved at this inquiry coming up and other inquiries. In fact, I think I've got 3 with Mr Trinick, 2 including with Mr Bell over the next week. And it just struck me that by the time this hearing occurs in May, the position in respect to MPF4 and the onshore wind policy statement will have been well aired, and it may be a matter that you consider either now or later might be capable of being dealt with by written submissions, so avoiding the need for hearing on that. So matter for you, but whilst those matters are clearly, for the reasons you indicated earlier, very fresh at the moment, they will be somewhat less so in May.
Okay.
We'll still be requesting a hearing session. I'm sure we'll be horribly familiar with all the new material by then, but you may not. And we are addressing you on this, so I think we'd like to discuss matters in a hearing session.
Okay, well, we've got that programmed in anyway, so we've got a date set for that. Okay, I'll move on to the next point, which is around the timings for those sessions. Do parties consider that one day would be enough for the session on landscape and visual impact? Yeah. And in terms of policy and conditions, another day should be enough to cover that. Okay, so we've got 3 days booked out at the moment, which it would probably be sensible for us to keep in hand, but the Wednesday the 3rd through to Friday the 5th dates that we've got, I think what we are suggesting is that we aim for completing the work on Wednesday the 3rd, Thursday the 4th, but keep the 5th available at the moment too, just in case we need some overspill time. Does that sound sensible? Okay, thank you very much. Agenda item 6, I think we've covered this already. Dr. Gordon from Mountaineering Scotland, you've already talked about your intentions in terms of your providing your update, so I think that is already covered.
Yes, apologies, ma'am, for jumping in earlier, but you were talking about when documents were to be, and I thought it was helpful to clarify at that point.
Right, I thought you might mention it then, so it's fine. No worries. Items 7 and 8, again, we have also covered a little bit of this already, so I'll just try and skip through. We've discussed the duration, are aiming for 2 days. We've got availability, and that's been updated since the agenda was circulated. As I mentioned, the applicant and the council have since agreed to Wednesday the 3rd to Friday the 5th of May. We are able to accommodate either an in-person or a virtual inquiry or hearing session or set of sessions at that time. What are parties' preferences in terms of in-person, virtual?
Strong preference for in-person, a very strong preference. And if I may just go forward one step from that, the Lovett Hotel of Port Augustus has already hosted 2 public inquiries, and we've already established, forgive us for doing so in advance, that it is available for the 3rd to the 5th of May with the room that has been used to hold inquiries before.
Okay. Council, do you have any?
The Highland Council adopts a neutral view on the approach to hearings, but if there is to be an in-person hearing, then the Lovett Hotel is entirely suitable.
Okay, and is the capacity all right for that if there is still a little bit of distancing required?
But I would anticipate from this hearing, yes.
Okay, thank you very much. That's very helpful. Helpful to have looked at that already. Item 9, around the timetable for documents, we'll confirm in the note of the PM what we've discussed in terms so far on dates, procedures and timings. The applicant, Mr. Trinick.
Just one point on that. We have no idea what may happen on the 8th of February when Highland Council consider matters. It could go various ways, and I'm not going to anticipate. But if there is a need to further consider procedures after that date, then you might want to consider a second PEM, and maybe even to plug a date for that into the diary in the week beginning the 13th of February. I'm obviously you're under a minute of appointment to hold the inquiry, so I think we need to consider further procedures at that time.
Okay, yeah, I'll have a look at the timetable that we've put together and see how that fits in and whether anything else would need adjusting. Or maybe there's a bit of information on document handling I think I should go through first, but I've got various dates to suggest coming up, so we can look at the PEM date and how that fits in with that too. So the information that I just want to briefly go through. Firstly, the applicant will be asked to compile a core document list that can contain hyperlinks to documents that are already in the DPEA core documents library or that form part of the case file provided by the Energy Consents Unit. That's to ensure parties have access to the documents and to enable the case officer to compile the core documents easily. We will send through a link to the core documents library with the PEM note. Something that's changed a little bit in terms of procedure. For recent Section 36 inquiries, DPA has been uploading inquiry documents and precognitions onto USBs and sending those to parties just before the inquiry starts. But that has been proving to be a bit inefficient. And there's been some issues with data protection and control that can cause difficulties, as can postal delays. So for those reasons, DPEA from now on is going to use Connect to share documents with parties. That allows parties to download the documents onto laptops or their own USBs for use at the inquiry. You'll have instant access and updating documents will be easier. All documents will also be published on the public website. Do parties have any comments on that? No. Okay, thanks very much. So turning to some of the key anticipated dates, this was all drafted before any of the updates today, of course. In terms of the note of this meeting, I'm proposing to circulate that by the 1st of September, 1st of February, which is a week tomorrow. I've got at the moment the 7th of February for commencing further written submission processes. But a note we've discussed that there are some ongoing discussions between parties, so I will update that and put the updates into the note. I had the 21st of February down for any statements of agreement, draft conditions and core documents. Is that still plausible with the updates we've discussed?
I think should be pushed back if possible. Whilst the statement of agreements are very helpful and they tend to take some time to work up, but given the position of our lack of witnesses at the moment, to have that by the 21st of February with a decision potentially being made on the 8th of February is too hopeful.
Okay, so how much time post 8th of Feb would be realistic?
Really, as much time as you can give me. I mean, in the sense that I know that I'm almost certain that Wright Johnson Mackenzie will circulate a draft statement of agreed matters at an appropriate stage, and we will work on that accordingly. And frankly, if you set an appropriate end date, the parties are sufficiently well versed with working with each other that I think you can have some confidence that there will be a statement of agreed matters at the appropriate end date. It may be that would provide us with the flexibility in this case that's needed.
Okay. The next set of submissions that I've got noted are inquiry reports and hearing statements. I've got those down for the 7th of March, which is 6 weeks from today. Again, would they need to be pushed back?
Well, certainly, yes, please. Depends whether you look forwards or backwards, but 4 weeks before the 3rd of May would be the 5th of April. Either that week or the week before that would be what the council would prefer. Give us time to get our case in order, but either the 5th of April or the week before that.
Okay.
From our perspective, quite content to have these dates pushed back for obvious reasons. May I ask, through you, Madam, if the council is going to be appointing an external landscape and visual witness?
That's still under contemplation. Yeah. I don't think I can say more than that at this stage. It may not be, but that's still under contemplation.
Okay. Well, I think the week before the 5th of April would be preferred. If we can.
I'm very happy with that.
Okay, week before. Okay. I have got 11th of April down for recognitions. That's 3 weeks before the start of the oral process. Obviously, that's only a couple of weeks between the date we just suggested.
If we could say the 19th of April for that, I think once parties have each other's reports, should be fine.
That's fine, ma'am.
Okay. Yeah, and then that's the last date that I've got before the actual the 3rd to the 5th of May. So I'll re-profile that timeline.
Um,
The reports would be by 29th of March, just for your date. I think that's a week before the 5th of April.
The other quick question was about conditions. I imagine you'd like, would you like those delivered with the inquiry reports and hearing statements?
Yeah, the conditions and the core documents list I have down for the same timetable, so I'll just readjust those in line.
Yeah.
With that. In terms of post-inquiry and hearing sessions, I've got for now a proposal of 13th of June for council closing submission and 27th of June for the applicant's closing statement. Are those dates?
Yes.
Okay for now. Okay. Great. Okay, so I hope I've got all that noted down. Did that sound? Do you want to come in and say what at all? Okay, I'll reprofile those dates and include that with the PM notes, and I'll do it if I need to. I'll double check anything else in the meantime. Okay, moving on to agenda item 10, which is to do with site inspections. Ms. Hayward and I are planning to undertake unaccompanied site inspections in April ahead of the May inquiry and hearing sessions. Those site visits will include the site itself, landscape character units, the viewpoints identified in the landscape and visual impact assessment, viewpoints, highlighted by all parties. We haven't yet identified any locations where we think it's essential to have an accompanied site visit, but if people do want to suggest any accompanied site visits, it would be helpful if you could do that over the next week. Are there any comments on that initially?
We'll do that, ma'am.
Okay, thank you very much. So that would be, well, actually I've put the 14th of February, so I'll let you have have that extra bit of time. Have that extra, too many dates swimming in my head. Okay, agenda point 11, Laura Walker, our colleague, is the DPEA case officer for this application. She'll be your main point of contact. You'll have been communicating with her already. Laura will liaise with Ms. Hayward and I and with yourselves as necessary. It's Laura that's responsible for making sure all the documents are circulated, made available on the website. And secondly, as I mentioned earlier, I'm going to circulate a note of this meeting by the 1st of February. Item 12, other relevant matters. I think I've covered everything I needed to. Do parties have anything else they want to ask or raise? No. Are you happy Mountaineering Scotland as well?
Yes, I am. Thank you, ma'am.
Okay, good. Thank you all very much for participating today and for those updates, which I will get to work on. Look forward to seeing you all in May in Fort Augustus. No, if there's no last comments, no more questions, then I'll close the meeting and look forward to seeing you again.
Thank you, ma'am.
Okay.
Thanks very much indeed.
Thank you very much. Thank you. Bye bye.